In the country's most arid state, few resources are as important as water. Nevada's limited springs and streams have been fought over long before the state joined the Union.
At the core of these disputes are water rights. To understand them, you have to know a few things about Nevada water law.
The state's law is an outgrowth of early mining law, and it's known as the doctrine of prior appropriation. What it essentially boils down to is this: water users who claimed a right to water first get a priority to water in times of scarcity and drought.
That means if I'm Farmer A in Lovelock on the Humboldt River and I have a claim to water dating back to 1916, I get my water before City A, which owns a water right dated 1960. In that situation, Farmer A would be referred to as having a senior right. City A, let's say Elko for this hypothetical, would have a junior right.
There are two other important aspects of Western water law. The first is that water users can only put their water to what's called beneficial use, for activities like mining or ranching, or making coffee. The second is that water users must use their entire allocation or risk losing their claim.
So why do we fight over water? The biggest reason often has to do with over-appropriation. Throughout the West and in Nevada, rivers and groundwater basins have been pushed to their limits.
Using rosy political predictions about the settlement of the West and less advanced hydrology, water planners in the past allocated more rights to water than there was actual water to go around.
Outside of Las Vegas and Reno, many towns and farms rely on groundwater stored under the valleys that pockmark the state. But water in many of these basins is over-appropriated too. There are many more rights to water on paper than there are in, say, River A or Basin B. The difference between so-called paper water and wet water is at the heart of many of these fights. If state regulators used a strict application of Western water law, they would cut off all junior rights holders to ensure that all the water goes to water users with priority senior rights. That is often unpalatable politically. Across the West, many towns and subdivisions have junior rights because they developed after agriculture. Curtailment could cause a big economic disruption in many areas, halting already existing development and economic bases.
State regulators have recently sought collaborative solutions like groundwater management plans, where water users from a particular basin or watershed come together and form local solutions to these problems. Some of the solutions have been creating a market where water rights can be bought and sold and traded and stay within one groundwater basin. Yet these solutions are imperfect too.
And more often than not, any decision related to disagreement over water ends up being litigated in court. There's one more factor looming in the background: changing temperatures. Because of climate change, the amount of water available is often, though not in all cases, expected to decrease, amplifying the challenges that already exist with overappropriation. Across the West, scientists have already observed a reduction in stream flow attributed to higher temperatures, the most visible signal of climate change. In the Colorado River, the source of 90% of Las Vegas's drinking water, a recent study pointed to a roughly 15% reduction in stream flow over the past century, with more than half of the reduction due to warmer weather.
As a result, water users from across the state have proposed making changes to or modernizing Nevada water law. Already, there are several bills in this legislative session that have been proposed by the state, which argues will bring more flexibility to Nevada water law in times of drought or scarcity amid a changing climate. But those bills face an uphill battle. Prior appropriation is sacred, not only in Nevada, but across the West.